Hello. Thanks for viewing our webinar for an overview and explanation of the rules regarding union dues election and financial disclosure. Before we get into the main content of the presentation, let's define a couple of terms. Union, or unions, refers to unions in Alberta, but also associations in their role as bargaining agents for their members, such as academic staff, graduate student, or postdoctoral fellows associations. The term union dues refers to union dues, assessments, or initiation fees. Union dues elections allow dues payers to elect to pay non-core union dues. Non-core dues are those that fund non-core union activities. Core union dues are used to directly fund core union activities. The rules for union dues election and union financial disclosure were initially introduced in July 2020 as part of the Restoring Balance in Alberta's Workplaces Act. The Act included requirements for unions to provide financial statements to their members. It also required unions to allow their dues payers to choose whether to pay the portion of their union dues that go towards funding political activities and other causes. This includes social causes, charities, non-governmental organizations, or organizations supportive of a political party. These rules for union financial disclosure were introduced to ensure union members receive information about their union's financial situation and clear and accurate information on how their dues are being spent. Many unions already provide this information to their members, but this will ensure there is a consistent baseline in information provided. The rules for union dues election were introduced to protect workers from being forced to fund political activities or causes that they may not support. To provide unions and employers with more clarity and detail on how to implement financial disclosure and union dues election requirements, Alberta's government has developed regulations. Before moving into the details on the regulations and their effective dates, let's outline the categories of workers to which these rules apply. Affected workers include unionized workers in the private and public sectors who fall under the Labor Relations Code and the Public Service Employee Relations Act. Union financial disclosure and union dues elections also apply to other workers who fall under specific pieces of legislation. This includes police officers and teachers. It also applies to academic staff associations, graduate student associations, and postdoctoral fellows associations at post-secondary institutions in those associations' capacity as bargaining agents. This presentation will cover the regulations for union financial disclosure before providing details on the process for union dues elections. Beginning on August 1, 2022, whenever a union's fiscal year ends, they must provide financial statements in a way that conforms with the regulations. This means financial statements must contain enough information to accurately disclose the financial condition and operation of the union to its members. Specifically, the financial statements must cover the preceding fiscal year and include information about income and expenditures, assets, and liabilities. Unions must provide financial statements to their members in writing, free of charge, and in a way that is accessible and allows them to keep the statement and review it in the future. To ensure the information in the financial statement is accurate, it must be verified and signed by a person with sufficient knowledge of the financial affairs of the union. Aside from these requirements, unions are free to prepare and share their financial statements in a manner that works best for them. As there are no further requirements for union financial disclosure, we will now move on to discuss the rules and processes for union dues elections. Union dues elections allow dues payers to elect to pay non-core union dues. All dues payers will continue to pay core union dues, regardless of whether or not they have elected to pay non-core dues. Unions can begin election processes for their dues payers to choose whether to pay non-core dues at any time, as the rules for union dues elections took effect on February 1, 2022. Unions have until July 31, 2022 to give dues payers their first opportunity to make an election. If dues payers do not make an initial election, employers can only deduct union dues to fund core activities. Beginning August 1, only dues payers who have elected to pay non-core dues will continue to pay these dues. If dues payers are not provided an opportunity to make an election or revoke a previous election when required, they can bring their concern to the Labor Relations Board. In order for union dues payers to make an election or revoke a previous election to pay non-core dues, there has to be a clear distinction between what activities union dues can elect to pay for, which are called non-core activities, and activities for which they must keep paying dues, which are called core activities. Alberta's labor relations legislation provides a framework for defining core and non-core activities. Core activities are activities under Alberta's Labor Relations Code, including activities that relate to collective bargaining and representation of members. Non-core activities are political activities and other causes, including general social causes or charities, non-governmental organizations, and organizations or groups affiliated with or supportive of a political party. Non-core dues must relate to these activities to be considered non-core. The election of union dues regulation adds additional activities that are core and non-core. In particular, an activity that directly benefits dues payers in the workplace is a core activity. An activity that does not directly benefit dues payers in the workplace is a non-core activity. The regulation also provides further clarity on core and non-core activities, including a number of activities that are considered core so long as they directly benefit dues payers in the workplace. For example, when a union engages in collective advancement and advocacy of workplace goals that are a direct benefit to dues payers, this is considered a core activity. This could include participating in legal proceedings, creating public awareness about an issue, and fulfilling legislative responsibilities. Other core activities are those that involve supporting or representing dues payers in their employment or in a matter related to their employment. For example, providing benefits, funds, education or training, or representing or supporting a dues payer at a hearing or investigation are core activities. Finally, administering collective agreements, collective bargaining, and conducting activities related to the governance and administration of the union would also fall under core activities. Examples of governance and administrative activities include administering the union's bylaws and constitution, activities related to certification, education and training union staff, and hiring halls. Even with the definitions and examples described, there may be situations when it is difficult to decide if an activity should be considered a core activity or a non-core activity. A single activity could have aspects that make it a core activity, while other aspects would not qualify as a core activity. If a single activity has core and non-core parts, the primary purpose of the activity will determine how it is classified. This principled approach can determine whether an activity should be considered a core or non-core activity if it is not immediately clear from the definitions in the regulation. A principled approach provides flexibility for unions when they consider whether their activities are core or non-core. Unions can use core union dues to provide funds to third parties for their activities if the union can show the funds have been or will be used for a core activity by the third party. Defining core and non-core activities is important because it helps unions apply the legislation and review their activities and determine which activities and related portion or amount of dues are core and which are non-core. This, in turn, helps unions provide details to their dues payers regarding core and non-core dues, which is required for union dues elections. Before any dues payer makes a decision about whether to pay non-core dues, they must have information from their union that allows them to make an informed decision. This information includes a list of the union's anticipated non-core activities or the people or entities the union intends to fund using non-core dues. Unions must also provide their members with a breakdown of the amount or percentage of union dues that goes toward core dues and the amount or percentage that goes toward non-core dues. This breakdown needs to provide the total amount of core and non-core union dues that the union expects to collect, and the related core and non-core amounts that individual dues payers are responsible for contributing. Dues payers can also reasonably request information from their union that is necessary to make an informed decision, and unions must respond to these requests. Unions will need to have contact information for their dues payers in order to give them information about their dues and elections. To help make sure unions can contact dues payers, employers must provide unions with employees' names and contact information as soon as is practicable once an employee is first required to pay core union dues. Dues payers must have the opportunity to make an initial election to pay non-core union dues before July 31, 2022. Dues payers must be given the opportunity to make an election or revoke a previous election to pay non-core dues at least once a year, or more frequently if specified in a collective agreement. A dues payer must also be given an opportunity to make an election to pay non-core dues when they are first required to pay core union dues, such as when they are first hired. As part of their business, unions may need to make material changes to the amount or percentage of union dues that are considered non-core dues. If this occurs, unions must give dues payers an opportunity to elect or revoke a previous election to pay non-core dues prior to making the change, even if this occurs outside of the annual period or other periods if outlined in a collective agreement. Election and revocation periods must take place every 12 months, or more frequently if outlined in a collective agreement, or if there is a material change to the non-core dues amount. This gives dues payers an opportunity to make or revoke a previously made election. There are requirements for both elections and revocations. Specifically, elections and revocations must be in writing, which can include electronic forms, include the name and signature of the dues payer making or revoking the election, and be signed by an official authorized by the union. When dues payers are making an election, the written election form must state that the employee agrees to pay non-core dues, including any non-material changes to the amount of non-core dues they are paying. The form must also include the amount or percentage that will be charged to the employee for non-core dues at the time of the election. When an employee is revoking a previous election, the written form must clearly indicate that an employee is revoking a previous election to pay the amount or percentage of dues going towards non-core activities. Once a dues payer has chosen to pay non-core dues, they will continue paying these dues until they revoke their election in a future election period. When a dues payer has chosen to pay non-core dues, the union will charge or collect these dues. The employer will deduct non-core dues from a dues payer's paycheck as soon as is practicable after an election, unless the union collects dues directly from dues payers. If a dues payer revokes an election to pay non-core dues, the union must stop charging or collecting these dues. The employer must stop deducting non-core dues from a dues payer's paycheck as soon as is practicable after a revocation, unless the union collects dues directly from dues payers. The rules for union dues election I have just described apply to all unions and their dues payers. However, there are a few situations that require some additional considerations. Some employees, such as those in the construction sector, differ from many other dues payers because they may not pay union dues on a continuous basis. Instead, whether they pay union dues is generally based on their employment status. These employees only need to make a choice about whether to pay non-core dues the first time they begin paying core dues to a particular union. They do not need the opportunity for an initial election each time they join a new employer that has a bargaining relationship with that same union. Some bargaining agents who also serve as associations or have academic or professional governance roles for their members are other groups that require some extra considerations. This includes the Alberta Teachers Association and academic staff, graduate student, and postdoctoral fellows associations. Dues payers will continue to pay core union dues as well as fees related to their association's professional development and professional governance responsibilities. The rules I have described are designed to be as flexible as possible in order to ease administrative burden on unions and employers, while offering union dues payers increased transparency and choice regarding their union dues. While government has tried to make these rules as simple as possible, we understand there could be some areas where people are looking for clarification. We have received a number of questions related to the regulations, which we would like to address today. First, we would like to clarify that unions can continue to make donations to charities. However, if they use union dues collected after July 31, 2022 to fund these donations, they must only use the portion that dues payers have opted to pay for non-core activities. Unions must ensure their dues payers have the opportunity to make an election at the times discussed earlier in this presentation. However, unions have the flexibility to determine how long in advance of the election they provide required information in the legislation for dues payers to make an election. Additionally, they have the flexibility to determine how long dues payers will have to make a decision. We have also received questions about what happens if the rules for financial disclosure and union dues election are not followed properly. We are encouraging unions and employers to work together to implement union dues election rules. If unions, employers, or employees are concerned that the rules regarding union dues elections are not being followed properly, they can file a complaint with the Labor Relations Board to have the dispute resolved. If you are looking for more information on what is included in the Restoring Balance in Alberta's Workplaces Act and regulations, you may email us using the email address on your screen. However, we can only provide general information about the legislation, and the information we provide is not legal advice. If you are looking for advice on how to interpret or apply this legislation at your union, we encourage you to seek legal counsel. Thank you.